Hi and welcome to the second video about Legal Studies HSC by LOLHSC. So in this video we're going to have a look at the dot point, the first dot point in the Learn To column, describe the nature of crime. And this dot point covers quite a few areas, which for me, the way I attacked it was to break it down into a series of questions, and this helped me a lot when it comes to multiple choice and kind of including everything that such a broad area that you need to know for this dot point into a much more succinct structure. So I have 5 questions here. What is crime? Then we have how do we classify crime, and then what inherent tension is present. This is really key because of the core focus of the actual topic. Then we have what are the elements of a crime, and do they all need do all the crimes need these elements? So first of all, we'll have a look at what is crime. So this is from the Australian Legal Dictionary, and a crime is defined as any conduct which violates the rights of the community at large, punishable by a recognised criminal sanction upon proof of guilty in a criminal proceeding initiated. Alright, so pretty much that's the really proper definition of a crime. But really a crime is just something that is agreed to be against the morals of the society or community that you're living in. And also something that's important to note is that not acting can be seen as a crime. A good case of this is called R vs Thomas Sam. Also another one, Manju Sam, in which these two people were charged with criminal negligence for refusing to allow the child to be treated with conventional medicine, and the child died. So these were the parents of a child, and because even if the beliefs, because the child died, they did not act and allow medication to be given, it is classified as a crime. So then we move on to how do we classify crime. So the classification of crime can often differ between societies. This is due to the changing public morality and the law as a reflection of this. A really good case, even though it's a very different time period, and it'll be a very strange question if it does come up in the crime essay one. A good cases to look at is when you consider the Witchcraft Act 1785 changing to the Crimes Amendment Computer Offences Act 2002, New South Wales. So you can kind of see that we went from having a law that was related to witchcraft, which today is nonsense, to something relating to computer hacking, showing that as public morality has changed, and as with that technology as well, that the law has responded, and in turn crime is classified accordingly to what our beliefs are, or society's beliefs. And then we move to the next part. So just to summarize that, how do we classify crime? It's pretty much by our beliefs in society and the standards that are set by society. What inherent tension is present? This is a very important dot point, as 2 years ago in the crime question, the word tension was used, and it put off a lot of students. Now, this tension comes up. It comes up when you're trying to balance the rights of the community and those individuals when attempting to investigate, prosecute, and punish criminal offences. So pretty much, the law tries to balance the rights of the offender with the offended, and that of society. And when you try and balance all of those, you're going to get some tension, because sometimes by doing one thing, it's not going to quite really have a balance between the offender and the offended, and it tries to balance that. However, in cases there can be a tension created because it may not. Now we move on to the second last question, which is what are the elements of a crime? The elements of a crime are mens rea and actus reus. These are Latin terms. So we have mens rea. Mens rea is a very important when it comes to crime. as it means the guilty mind. The guilty mind meaning that they had the intention to create to commit the crime, and they had a knowledge of what their what their actions would result in. This is compared to actus reus, which simply means the act of committing a crime. A lot of people can get confused by saying it's the guilty act. It's not the guilty act, it's simply just committing the crime itself. Alright, so we have to move on to another part within this area. It's called causation. So for there to be okay, sorry about that. So causation is pretty much the link between the act and the crime itself. So pretty much that there has to be a link between this act and the crime, and that is known as causation. So for example, there's I think there's a Thomas Kelly case where he's punched him and he's fallen over and hit his head. So the prosecutors have to establish that and to show that the damage of cause and the death was caused by him punching the person in the head, not him falling and hitting the head, because if he didn't die from a punch, then technically it wasn't murder. But what you have to say is that there that causation that because he's punched him he died. It wasn't the fall to the curb that killed him, it was actually the punch. Yeah. And also there's another case that you can use is RV Monster 2009, in which the accused punched an elderly who consequently suffered a heart attack and died. So that's an example of a case where causation can be used, because they punched him and as a result he had a heart attack and died. And then, do they all need these elements? No, they don't. In simple terms, there's offences called strict liability offences, and this is where the prosecution does not need to prove they intended to commit the crime. All they have to prove that the act was committed. For example, speeding. Anything where you have speeding or drink driving, they're known as strict liability offences, and the prosecution does not need to prove that you intended to.